Evelyn Reed, a highly successful, recently retired accessibility consultant and a veteran disability rights attorney, viewed the world not through the lens of aesthetics, but through the uncompromising, objective framework of the Americans with Disabilities Act. Her professional life had been spent establishing and enforcing the standards of Title III, making the built environment compliant with federal civil rights law. She lived with the quiet certainty of a person who had spent decades successfully fighting for the fundamental rights of others, even as she navigated her own life using a sophisticated motorized scooter, following a long-ago accident that impacted her mobility. Her custom-built home in the sprawling, upscale community of the Preserve at Whispering Pines was a haven, but the final approach to her front door, a single, elegantly designed, yet highly dangerous elevated step, was a daily, frustrating obstacle. Seeking a practical, low-impact solution, she submitted a simple, reasonable accommodation request to the Homeowners Association, a minor, custom-built wooden ramp stained to precisely match the existing mahogany porch trim, estimated to cost a mere $1,200, which she offered to fund entirely herself. Her request landed on the desk of Marcus Albright, the powerful, highly entrenched HOA Board President. Albright, a man whose worldview was limited to maintaining soaring property values and enforcing the neighborhood's pristine, non-negotiable aesthetic homogeneity, embodied casual yet profound ableism. His response was swift, dismissive, and infused with open contempt. He rejected Evelyn's request, citing the community's strict architectural standards that prohibited any visible deviations from the master plan and the unjustifiable precedent such a structural modification would establish. He elevated the rejection by suggesting, in a cold, arrogant follow-up email that quickly became central to the forthcoming lawsuit, that residents with specialized mobility requirements should perhaps have exercised greater foresight and chosen properties more suited to their particular physical limitations when purchasing in this community. Evelyn did not argue. She did not appeal to the board's governance committee, nor did she engage in any further dialogue with the HOA management. An appeal would have been a waste of precious time and, critically, a tacit acknowledgement of Albright's perceived authority over indisputable federal law. The fight would not be won in a local board meeting. It would be settled in federal court. Instead, she retrieved her professional-grade equipment from her home office, a room organized around the statutes, codes, and regulations of the ADA Accessibility Guidelines, ADAAG. She knew that the Preserve at Whispering Pines, as a common interest development built after 1990 whose common areas functioned as places of public accommodation, was undeniably subject to the full weight of ADA Title III mandates. Albright, in his petty, uniformed arrogance, had just made the gravest, most expensive mistake of his entire tenure. He had personally invited a federal civil rights attorney and certified accessibility expert to conduct a full, forensic compliance audit of his multi-million-dollar community. For the next 3 weeks, Evelyn, utilizing her own specialized surveying tools including laser levels, digital protractors, and a specialized digital inclinometer to measure ramp slopes, conducted a comprehensive, expert-level ADA compliance survey of every single common area structure within the Preserve. She moved systematically, documenting every failure of access with ruthless precision, building a body of evidence that was legally unassailable. She started with the pool changing rooms, where she found grab bars that were misplaced by a few critical inches, and toilet centerline measurements that failed to provide the necessary clearside transfer space required by the ADA. The pool itself lacked a compliant, permanently installed entry lifter requirement for public accommodations. She meticulously documented the lack of accessible vanity sinks and the illegal locking mechanisms on emergency call boxes. She moved to the clubhouse, where the main entry doors were too narrow, lacking the required 32 inches of clear passage width, and the interior sign systems failed to incorporate mandated tactile or braille lettering, a violation for vision-impaired individuals. The fitness center equipment was placed in non-compliant clusters, lacking accessible approaches, and the main community meeting room required a 4-foot turning radius her scooter could not manage, effectively barring her and other wheelchair users from attending community votes. The community's pride, the brand-new scenic paved walking path to the community lake, was bordered by access ramps at pedestrian crossings that shockingly exhibited an illegal slope of 1:8, nearly double the maximum allowed 1:12 ratio, creating a severe, hazardous instability for manual wheelchair users. She documented 64 distinct, systemic ADA violations across 12 different common elements. This was not a few minor lapses. This was a complete, systemic, years-long failure to adhere to civil rights law. The accumulated cost to retroactively correct the entire structural failure was going to be astronomical. Evelyn immediately ceased all contact with the HOA. The documentation phase was over. The litigation phase had begun. She compiled her evidence into a pristine, professionally sealed forensic report of systemic access denial, a 120-page document complete with photographs, GPS coordinates, and specific violation citations for every measured failure. She delivered this report not to the board, but to Ms. Sophia Diaz, a powerful civil rights attorney known for securing landmark multi-million-dollar federal ADA settlements. The strategy was clear: bypass the local, state courts, which might be sympathetic to the HOA aesthetic arguments, and deploy the full, uncompromising jurisdiction of the federal system. Ms. Diaz filed a massive federal class action lawsuit Reed v. The Preserve at Whispering Pines HOA et al. On behalf of Evelyn and all other disabled residents. The suit sought both injunctive relief, a mandatory, time-bound court order to fix all violations, and significant statutory damages for every single day the community had been inaccessible, multiplied by the potential number of disabled residents who had been illegally denied full participation. When the summons arrived, accompanied by Evelyn's unassailable forensic report, the HOA's general counsel, a man accustomed to handling boundary disputes and overdue fines, immediately went into a state of professional panic. He advised the board that their position was legally indefensible. The ADA, as a federal civil rights mandate, superseded every single local aesthetic bylaw, and the sheer volume and systemic nature of the violations exposed the HOA to financial ruin far beyond their insurance coverage. He warned them that due to the explicit, willful, and documented denial of Evelyn's initial simple accommodation request, the court would likely view this as a malice-fueled civil rights violation, maximizing the penalties. They could not dismiss the threat as a minor technicality. The federal court moved with the speed and certainty of a judicial steamroller. Given the irrefutable, expert-level evidence provided by Evelyn Reed, the court ruled decisively and instantly against the HOA. The final court order, handed down by the presiding federal judge, was financially crippling and operationally absolute. The HOA was mandated to undertake sweeping, non-negotiable structural renovations across the entire community, including installing new, compliant 112 maximum slope ramps at all required access points, widening all entryways and doors to the federal minimum of 32 inches clear passage width, completely retrofitting the pool and clubhouse restrooms to meet modern ADA standards, installing a compliant pool lift, and replacing all non-compliant interior and exterior signage, a project that the court-appointed independent construction auditor immediately estimated would cost the community in excess of $3.8 million. Furthermore, recognizing the willful, bad faith denial of Evelyn's simple, low-cost ramp request, the court awarded Evelyn Reed substantial statutory damages for discrimination and ordered the HOA to pay all of her extensive attorney's fees in full, a sum approaching $500,000. The financial fallout was instantaneous and total. The multi-million-dollar remediation cost, coupled with the damages and legal fees, instantly decimated the HOA's entire reserve fund, which held less than $500,000. The board was forced to initiate a massive, non-optional, emergency special assessment on every single resident of the Preserve at Whispering Pines, totaling an average of nearly $45,000 per home, payable within 90 days. The community descended into financial and social revolt, turning their furious attention from Evelyn to the board that had invited disaster. Victor Thorne, the president, was not only personally censured by the federal judge for his willful and malicious discrimination, but was publicly and humiliatingly removed from the board within hours of the court's ruling, facing immediate lawsuits from furious homeowners. Evelyn Reed's small, necessary ramp was now built, not by her own expense, but by the HOA's ruined coffers. She had used the absolute, uncompromising authority of federal law to demolish the HOA's ableist leadership and ensure that access, not Marcus Albright's outdated aesthetic sensibilities, became the community's primary and most expensive legal standard.